Good afternoon, ma'am. I'm Emeritus Garcia. I am from Group 12, and my group and I will be reporting on transboundary pollution. I'll be discussing the problems of pollution. So first, what is pollution? Pollution is the action of polluting, especially by environmental contamination with man-made waste. As both population and production increase, the risk of pollution are causing a negative impact on our environment increases. So, by the progress we attain through industry and technology, these advances cause us to produce waste which we negligently throw out and affect our environment. By such, we cause the environment to degrade, and this causes negative impact in the world we live in today. So what is transboundary pollution? Transboundary pollution is a pollution not contained by a single nation state, but that travels across national borders at varying rates. One of the easiest ways for pollutants to travel is by the air. Air pollution has no regard for national boundaries. Difficult, if not impossible, is air pollution to litigate in an international scale. So by this, we see that transboundary pollution is pollution that comes from one state and affects other states, maybe neighboring or even distant from it. Just as the example of air pollution, where in where factories or emissions from cars come up to the air and travel across the globe and affect other nation states, such as the case which was cited in Al Gore's documentary, where Australia is the one being affected by the greenhouse emissions from Europe and North America. So I will be yielding the floor to Jenny.
Good day everyone, my name is Jenny and I will be reporting on climate change in relation to transboundary pollution. The effects of transboundary pollution may vary depending on location to another location as explained by the previous reporter. But one thing is common, and it is climate change. Climate change is a natural occurrence all over the earth, and it has recently been overwhelmed by the greenhouse emissions of humans from fuel burning, agriculture, deforestation, and other related activities pertaining to the advancement of civilization. And this influenced the Kyoto Protocol. The Kyoto Protocol is a multi-party international agreement between nations agreeing to take steps in decreasing or limiting greenhouse emissions all over the world, going so far as to charging fines against those countries with high or uncontrolled greenhouse emissions. The Philippines is not to shy away with the awareness and the conscious effort to alleviate transboundary pollution. As embodied in the 1987 Philippine Constitution, it states that the state shall protect and advance the right of the people to a balanced and healthful ecology in accordance with the rhythm and harmony of nature. Moreover, in Oposa versus Factor, the Supreme Court ruled that the petitioners had locus standi to sue in representation of future generations so as to protect the environment and the constitutional right of a balanced and healthful ecology of subsequent generations. Furthermore, in AM number 0968 SE, a writ called the Writ of Kalikasan was issued by the Supreme Court, and this is a remedy available to a natural or juridical person, entity authorized by law, people's organization, non-governmental organization, or any public interest group accredited by or registered with any government agency on behalf of persons whose constitutional right to a balanced and healthful ecology is violated or threatened with violation by an unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces. Also, the petitioners may avail of another writ, and this writ is called the writ of continuing mandamus. This is to assure that compliance with the order of the court with relation to the environment will be observed. Also, the Philippines has already signed and participated in an ASEAN agreement on transboundary haze pollution. This said agreement seeks to prevent and monitor transboundary haze pollution as a result of land and forest fires, which should be mitigated through concerted national efforts and regional and international cooperation. This should be pursued in an overall sustainable development. However, this agreement does not yet have any international court or committee that would hear and adjudicate any damage caused by the pollution produced by one state to the other. It could be concluded, therefore, that such agreement is only for the sake of prevention, but fosters no true compensation for loss or accountability. Next slide, please. In Georgia versus Tennessee Copper Companies, the state of Georgia filed a bill in equity, and this is to enjoin the defendant copper companies from discharging noxious gases from Tennessee to Georgia. The allegations of the state of Georgia are the following. That first, the consequence of discharge leads to a wholesale destruction of forests, orchards, crops, and other injuries in their countries. And second, an application to the state of Tennessee for relief. However, a preliminary injunction was denied because the very elements that would be relied upon in a suit between fellow citizens as a ground for equitable relief are wanting in this case. The state owns very little of the territory alleged to be affected, so the damage is also relatively small. Also, the alleged damage to the state as a private owner is merely a gateway. Therefore, there are two issues in this case. The first issue is whether or not the state of Georgia is entitled to an injunction. For this issue, the court held that injunction is entitled to the state of Georgia. When the states by their union made the forcible abatement of outside nuisances impossible to each, they did not thereby agree to submit to whatever might be done. They did not renounce the possibility of making reasonable demands on the ground of there still remaining quasi-sovereign entities with quasi-sovereign interests. The state is somewhat more certainly entitled to specific relief than a private party might be. The court also found that the state of Georgia is entitled to the relief sought not because it is a state, but because it is a party which has established its right to such relief by proof of evidence. It is a fair and reasonable demand on the part of a sovereign that the air over its territory should not be polluted on a great scale by noxious gases. And whatever domestic destruction they have suffered should not be further destroyed or threatened by the act of persons beyond its control. This includes their forests, orchards, crops, and the like. On the evidence presented, the court is satisfied by a preponderance of evidence that the sulfurous fumes by the noxious gas caused and threatened damage on so considerable a scale to the forest and vegetable life, if not the health within the plaintiff state. Whether Georgia, by insisting upon this state, is doing more harm than good to her own citizens is for her to determine. The possible disaster to those outside the state must be accepted as a consequence of her standing upon her extreme rights. On the second issue, the issue is whether or not the state of Georgia is barred by laches, and the court held that that the state of Georgia is not barred because there was diligence shown. The plaintiff now finds or thinks that it finds that the tall chimney in present use of the copper companies still cause poisonous gases to be carried to greater distances than ever before, and that the evil has not been held over the years. My co-presenter will now talk about the approaches.
Good evening, ma'am. I'm Bayani, and I will be talking about the Let's Not Cheat Elective principle. So this principle is actually described as a law of the place where the injury or the tort or delict was committed or where the damage is suffered or inflicted. So in this case, the domestic law may be applied to polluting activities which actually has a foreign source or which comes from a foreign country. This is based on the principle of the vested rights doctrine. So according to this doctrine, the cause of action of the plaintiff is based on the law of the jurisdiction where he suffered the injury. So in this case, if there is a foreign country or a state where the tortious act is committed and the tortious act is felt in another state or in another country, then the law of the place where the tortious act was felt will control. Now, I will be discussing the case of Paputas versus Teccominco. In this case, on Teccominco Metals, the respondent is actually a Canadian company. So it operates a lead zinc smelter in British Columbia. Now it discharges about 145,000 tons of waste annually into the British Columbia River. And now, what happened was the Colville tribes, they petitioned the EPA or the Environmental Protection Agency to conduct an investigation regarding the contamination of the Columbia River. Now the EPA, through its investigation, it found out that indeed the Columbia River was actually contaminated with several hazardous substances. For example, like lead, zinc, copper, mercury, arsenic, etc. So now the EPA issued an order to conduct a feasibility report or investigation study by the Teccominco. However, the Teccominco in this case, it did not comply with the order. The order is actually based from the CERCLA, or the Comprehensive Environmental Response, Compensation and Liability Act. So the petitioner, we have Paputas and another person, Michael. They are both members of the Colville tribes. So they are located in the United States, but because the discharge of the pollutants, they actually were flown by the water current into the United States. So they filed a citizen suit to enforce the order of the EPA. Now, Teccominco, the respondent, it actually has two grounds for its motion to dismiss. So the first ground is that the U.S. does not have jurisdiction over them, mainly because they are a Canadian company and they are incorporated in the U.S. and they are not doing business they're not doing business in Canada, but they're actually not operating in the U.S. Their first contention and their second contention is that the CERCLA has no extraterritorial application. So the issue in this case is whether or not the CERCLA involves an extraterritorial application of a domestic law. Now the Ninth Circuit Court held that the CERCLA actually imposes liability for the release or the threatened release of the hazardous substances and not really for the disposal of such substances. So the goal actually of CERCLA is to impose liability for the costs of the cleanup of the river. Now, since the leaching, it was actually felt in the U.S., so it involves now a domestic application of the CERCLA. Now, the Paputas is of the position that so long as there is a domestic connection with the act performed, it will not actually amount to an extraterritorial application of the law. Since the effects in this case are felt locally, like the principle of the lex loci delicti, now there is a link or a causal connection for the application of the domestic law. So this is actually a multi-state event and not an extraterritorial application. Thank you. Now, the next principle will be discussed by Ms. Lopez.
Good day, ma'am. I will be discussing the last two approaches to transboundary pollution. The second one is government interest analysis. What is the government interest analysis? The government interest analysis approach requires the application of the law of the state with the greatest interest in resolving a particular issue that is raised in the underlying litigation. In this particular approach, the courts must compare the laws and interests of the two states and then determine whether or not a conflict exists. If indeed a real conflict exists, the courts must apply the law of the state whose interest is more impaired. This is pursuant to the doctrine of District of Columbia versus Coleman. Now, why is it important to consider the interest of the states? It is important to consider the interest of the states due to the nature of commercial transactions. Commercial transactions involve people located in several locations and jurisdictions and therefore, they also have conflicting interests in a specific transaction. This interest may have been a motivating factor in the agreement of the parties, and so it should be properly considered. The government interest analysis approach involves 3 steps. The first step is to compare the laws and interests of the 2 states. The second is to determine if there is indeed a real conflict in the application of the law of a specific state. And the last one is if indeed a real conflict exists, the courts must apply the law of the state whose interest is more impaired. The next approach is the most significant relationship approach. The most significant relationship approach states that examination must be made as to the state that has the most connection to a case. According to the most significant relationship approach, the law of the state which has the most connection shall be applied in the resolution of a conflict. According to the case of Cost versus Union Supply Company, the rights and liabilities of the parties with respect to an issue in court are determined by the local law of the state which has the most significant relationship to the occurrence and the parties. In the restatement, second conflict of laws, there is an enumeration stating the points of contact in order to determine which law of the state shall be applied. According to the restatement of the conflict of laws, the following points of contact should be considered. The first is the place where the injury occurred. The second is the place where the conduct causing the injury occurred. The third is the domicile, the residence, nationality, place of incorporation, and place of business of the parties. And lastly, the place where the relationship, if any, between the parties is centered. This particular enumeration is applied in the case of Nadili versus Chevron USA Incorporated. In this case, plaintiffs Nadili et al. Were current owners and residents of Riggs Park neighborhood in Washington, D.C. Nadili et al. Sued Chevron Incorporated for having operated a gas station which according to them, contaminated the air, soil, and groundwater of the properties currently or formerly owned or occupied by the plaintiffs, resulting in the diminished values of their properties. Now, the issue in this case is whether or not the Maryland law or the District of Columbia law applies, since the gasoline station was found in Maryland and the residents were from the District of Columbia, and due to the fact that there was only a border separating them, the contaminants from the gasoline station in Maryland worked its way to the District of Columbia, where it caused irreparable damage. Now the issue in this case is which law will apply, whether the Maryland law will apply or whether or not the District of Columbia law will apply. The court held that the District of Columbia law should apply. Pursuant to Section 145 of the Restatement, Second Conflict of Laws, it states that the points of contact must be considered, which is the place of injury, the place where the conduct causing the injury occurred, the domicile, residence, place of incorporation, and place of business of the parties, and the place where the relationship between the parties is centered. Applying the above-mentioned factors to the instant facts, the court finds that between the District of Columbia and between Maryland, the District of Columbia has the greater interest in the outcome of this litigation. While Chevron's conduct occurred mainly in Maryland, where its former service station and underground storage tanks are situated, and a handful of the plaintiffs currently reside in that area, all of the alleged contamination at issue in this litigation occurred in the District of Columbia. All of the alleged injuries happened in the District of Columbia. And the overwhelming majority of plaintiffs still reside in the District of Columbia. Hence, applying the points of contact where the injury occurred and where majority of the plaintiffs reside, the District of Columbia law must be applicable in this case, applying the most significant relationship approach. The court in this case cited Camel Guard versus Mukura in order to support their decision, which states that it must be noted that one point of contact in most significant relationship is the place where the injury occurred. Most states adhering to the most significant relationship approach place or allocate so much importance to this point of contact, since the state with the most significant relation to a claim is usually the state in which the tort occurred. Another doctrine to be considered in applying the most significant relationship approach is the doctrine of depassage. The doctrine of depassage states that the choice of law analysis is conducted on an issue-by-issue basis, and the various choice of law regimes describe themselves applying to each of the particular issues in this case. According to the restatement of conflict of laws, each issue is to receive separate consideration if it is one which would be resolved differently under the local law, rule, or two or more of the potentially interested states. So, the doctrine of depassage states that when there are varying issues, varying laws may also be applied in different issues if in applying the points of contact, that law must be applied in connection to the issue in the case at bar. And that's all for our report, ma'am. Good evening.